Before we started doing this work, all of our cases were being heard the same. If there was two feuding roommates, or if it was a husband and a wife and they had 4 kids and there was domestic abuse present, those cases would be handled the same way.
So we decided to do a pilot to take all of the civil protective order cases where parties had children in common on one calendar. We rolled it out in January of 2016 and slowed down the cases on those calendars so we could take the time to address custody and parenting time issues and child support issues and programming. After we did this pilot for a year, January of 2017, we decided to expand it to double the number of judicial officers. Our chief judge of the district really wanted to push towards sustainability and to not just have a select few do work on this calendar. And so we broke it out to everyone in January of 2018.
Hennepin is a very diverse and rich cultural community.
We know we're not perfect, and so we took the communities that are accessing our courts and then we went out to them and started talking to them about issues around access, around responsiveness, around the way that they're being treated in the courthouse. And we just simply asked the question, how can we do better?
You can't just take the issue of domestic violence and say, okay, here we've got these 3 outcomes and this is going to work for everybody, because it doesn't work for everybody. And then actually going and talking to the people who come to court and saying, what was your experience like? And accepting negative feedback and then saying, okay, we're going to make some changes. So going to the community, having listening sessions, but doing the listening, not the talking.
My recommendations have been centered around viewing the systems and then bringing those recommendations out to the community and saying, this is our new lens, we should be looking at it like this. Because when we step into the community asking them how the cultural piece is denying access, I think there's an assumption or an inference there that the system is working perfectly, and that's not the case at all. So I'm trying to remove that inference and saying we need to recognize that the system is broken, especially when it comes to people of color.
The needs of our Native community is much different than the needs of our Latinx community. For instance, the Native community feels fear of child protection intervention and that the court isn't respecting of their culture and their tribes and things like that. Whereas with the Latinx community, immigration is the concern, in that if they come to the court system, that there is a fear that they will be deported, or there's this extra pressure of keeping a family together if one of the spouses is undocumented. We realize that there is a large LGBTQ population in the Twin Cities area, but we've never once asked them how we're doing from a court's perspective on addressing their needs. And so we went to them. We went to advocacy organizations and organizations that are serving our LGBTQ community. And it was truly eye-opening that it says, we simply don't feel comfortable in your court system for many reasons, one of which is that a lot of people that we work with are trans, or they don't identify with the gender that was assigned to them at birth. But your court doesn't really seem to ask us about, what do you prefer to be called? What is the pronoun that you prefer to be asked? We were able to change our forms to include questions such as, what is your gender, male, female, non-binary, transgender, other, and then what is your preferred pronoun?
We can talk a lot about the broad terms or ideology of access to justice, but what does that really mean like on the ground? I grew up on the reservation up north, the hometown of Federal Dam, Minnesota, population 106. And coming from that is obviously a different experience than growing up in the Twin Cities. So I knew from my life experience and from some of my professional experience that my community is a community that is one of those that does not feel heard in the court system. I mean, we always joke with each other and say, hi, I'm the government and I'm here to help you. And it's never come true that there was assistance following those words. So knowing that, and then knowing the level of domestic violence within the Native community, for example, we knew that 1 in 3 women experience either sexual assault or physical assault in their lifetime within the Native community. So knowing that we have a very large urban Indian population, but we have another part of the court that actually could do something positive and something that's going to help. How do we bridge that?
I think the mistrust for the court systems for the Native American community is deep-rooted, stemmed for 200 years of shenanigans, federal shenanigans, that have not always worked for Native people. We don't see this as a place for a fair adjudication, if fair means credible and just. I think there is a barrier in the system itself. The court system in its design creates the barriers, and what the Native population are feeling are the impacts from those barriers. So for example, access to attorneys is a big one. We know that court cases generally do better when a client is represented by an attorney. Generally, when Native populations come from a reservation, for example, like Oglala in South Dakota, which is one of the poorest counties in our nation, they're not going to have the resources to access an attorney. And if it's a civil case, you're not going to have a court-appointed attorney to begin with. So there's a barrier right there. Transportation, I know a lot of our courts are going to e-filing, but you need a computer. Education is a big piece. I still have trouble going through some of the court filing procedures, and I think I'm pretty savvy with those. So I think the system itself is the barrier. The impacts are what I'm observing out in the community.
We've held 3 judicial listing sessions, and we've had between 15 and 20 judicial officers at each one of them. And the judges come in, and we have community members, and we have a feast for everybody, and we talk about things. What was your experience with the court system? What can the court do better? One of the things that was identified through this listening session and that we acted upon was, in the Native culture, smudging is a spiritual and a cultural practice, and it cleanses the space. And so what that does is it helps clear the air so people feel more comfortable to be in the situation, which can be really stressful, which court is quite stressful.
Behind me are the flags of some of our tribal nations. That is a huge acknowledgement of the existence of our 11 tribal nations and their sovereignty. If I'm a Native person, I walk in this courtroom and I see my flag behind the court, that tells me that this court knows that I exist. And that goes a long way to me feeling comfortable.
Seeing the flags for the Native community is a good step forward. Again, these are baby steps, because we've been hit with a semi, knocked 200 miles back, and now we're taking these baby steps forward. Sovereignty is about a sharing of power, and right now tribal nations don't share in that power.
We hired a Native liaison, and I think it's been one of the most successful things that the court has done, because if I'm a Native person and I know that I can call another Native person and they're going to help me navigate this huge system that they call a court, I have an extra level of comfort that I didn't have before.
We are at what was formerly named as Lake Calhoun here in Minneapolis, uptown area. Has been changed to the B'daymakah Lake, which is a Dakota word for, well, I'm not going to try to interpret it. It's a Dakota word. Because we're in Dakota territory, the Department of Parks and Rec honored this lake in recognition of the Dakota people, so by changing the name. We talked about the access to the court systems and what that looks like. This is a prime example of what that could look like as far as Dakota identity, Dakota sovereignty, recognition of the words here that are part of Dakota heritage. There are still many Dakota speakers in this area, and this is a great way to say we see you, we recognize the importance of this, and it creates the steps towards that mutual relationship.
It can be very challenging for courts to be the ones screening for domestic violence because the courts are neutral.
A lot of our cases are resolved through alternative dispute resolution processes.
Zach, Lydia, thanks for coming in today.
But it's not always appropriate to be referring those cases if there is domestic abuse present. It's important to know in cases if there is domestic violence because that can affect the way that custody and parenting time is addressed. The court has a lot of tools. One thing they can do is they can order supervised visitation, or they can order batterers intervention programming, or chemical and mental health dependency evaluations.
I'm just going to review the options that you have this morning. You have the option of admitting the allegations in the petition and agreeing that an order for protection can be issued. That order would stay in place for 2 years. There are a number of other requests for relief that we would talk about. You have the option of denying the allegations, and we can set the matter for what's called an evidentiary hearing or a trial where there would be testimony from each of you, and I would then make a determination whether or not domestic abuse occurred. However, the last option is that because this is not a criminal case, this is a civil case, you have the option of denying the allegations, not admitting that anything happened, but agreeing to the order for protection being put in place. We wanted to maximize opportunities for safe disclosure of domestic violence from the time somebody walks in the door to the end of the case. We give both parties things that you need to think about in terms of whether it is appropriate for you to want to participate in an alternative dispute resolution process. So, for example, do you feel safe being in the same room with the other party? Do you feel like you have enough autonomy to be able to talk about what you would like to see happen, what your concerns are?
Why that matters is that it's not just that if there is domestic abuse present that you should not be participating in this process. The problem was that a lot of these cases there would never even be a question as to is there domestic abuse present? There's not an order for protection in place. We'll just assume there's no domestic abuse present. The focus really should just be on the kids in these kind of situations too, because you don't want to put them in harm's way, and you also want to, if you can, build great relationships with the family. One of the things that we have trained essentially everybody that touches the court system with is on this safer approach. And so what this is it's a uniform approach in which everybody's looking at these cases the same way and we're speaking the same language.
The question is, first, when the courts look at it, is there domestic violence or intimate partner violence? If there isn't, you're done with that particular factor. If there is, then look at the nature and context of it. What's really going on? What's happened? And then the third approach, or the third prong of this, is to look at the impact on parenting of both the perpetrator and the victim, the impact on the children, and then finally, what do you do about it? How do you respond to all of that in terms of coming up with custody arrangements and parenting time arrangements? And that's just one of 12 factors, but that's how we look at it. It provides us a framework to look at this. And it is much more, I think, useful for the courts and also useful for attorneys, useful for parties in terms of explaining what's really going on.
From a historical perspective, the model that Hennepin County is using now provides much more comprehensive services to litigants and to survivors and batterers of domestic violence. Prior to the way that the court is set up now, all of the judges were hearing cases that were involving victims of domestic violence, perpetrators and children, and not all of the judicial officers had a good understanding of the dynamics that they were seeing in the courtroom.
We're getting these cases days before a court appearance rather than just minutes before a court appearance, and that gives us the opportunity, obviously, to prepare, subpoena witnesses, do a little bit more preparation. It also gives us the opportunity to meet with petitioners in order for protection ahead of time, even before they filed, and consult on drafting those petitions. There's also a greater focus on the other sort of social services, counseling for both the perpetrator of abuse and the children, and other sort of chemical dependency evaluations, and moving forward for real solutions for what the problems were for these families to help create sort of a more global solution.
This office is governed by the Hennepin County Attorney's Office. We specifically picked this place, this area, this location to be sort of incognito. We wanted to hide because we want to make sure and ensure victim safety as much as possible. The center really is a one-stop shop. A victim can come here and get multiple services in one place. The purpose the center was built on is to assist victims in filing an order for protection. But not only can a victim come here and file an order for protection, a victim can come here and get advocacy services. A victim can meet with a police officer, a prosecutor, get an order for protection written by district court, and then be able to also, from those services, you are able to give more and wraparound services and follow around services just because you have all those partners and partnerships here. And you can also meet with an attorney from Central Legal Services. It's beneficial to have a one-stop shop for victims because of the complexity of what's going on in a victim's life. I think that if a victim is going through domestic violence, how more frustrating is it that she'd have to go to the police department and talk to a police officer and then leave there with 3 kids perhaps and go talk to an advocacy agency and then leave there and then go talk to probation. And so that is really what was happening here in Hennepin County and Minneapolis 25 years ago, is that a victim had to go to multiple places. We really wanted to reach that community, those communities, the communities where victims and women did not speak English, the community where we know that there was poverty and crime and at-risk children and mothers. We have 2 Spanish-speaking advocates from Casa Esperanza. We have an advocate from the GLBTQ community. We have a contract with the DIW, Division of Indian Works. We got funds to hire advocates to work specifically in the African American communities and really just trying to bridge the gap between the government, the mistrust, the racial inequality or inequity, right? We also have a contract with Asian Women United. So if an Asian victim comes into our center, we're able to have an advocate that can meet those needs and understand the culture and speak the language. And then we have a Somali advocate as well.
I remember leaving the court system and I was just like, I almost just want to give up. I don't even want to do this anymore. But I remember the Domestic Abuse Project told me to go to the Domestic Abuse Service Center, and that's where I started receiving my best help. I feel like a better mom, for sure, hands down. It's like this undescribable feeling. I don't even know how to put it into words. It's just I'm going about my life and things are good.